Well, you're listening to
It's Your Money Radio.
It's Your Money Radio.
Yeah, we're talking to Scott Smith from Rooney McBride & Smith. And first of all, how do people get a hold of you if they want to talk about bankruptcy?
They'd want to call the office. It's 417-708-9681.
Okay, the office is of Rooney McBride & Smith, and you're located very conveniently at National...
Intersection of National and Lakewood, 4905
National.
South National.
4905, that's National in Lakewood. That's right by, what building is that? That big
New Gardner Capitol Building.
Gardner
right
Capitol Building. Everybody will recognize that. It's a big building right there on National. And if you're there, you're right next to your office.
That is correct.
Okay, so it's real easy to find, folks. Call, get an appointment, and stop by. And talking about bankruptcy, now there are a couple different kinds of bankruptcy, so why don't we start there?
Yeah, bankruptcies that individuals are primarily interested in or would have questions about would be Chapter 7 bankruptcy and Chapter 13 bankruptcy. I can discuss a little bit of the differences. A Chapter 7 bankruptcy is sometimes referred to as a liquidation bankruptcy. In a Chapter 7 bankruptcy, if you're able to qualify for that type of bankruptcy, you can file and discharge the majority of your unsecured debt, so credit cards, medical bills, and other unsecured debt without having to pay back on any of that debt over a period of time. There are income thresholds for a Chapter 7 bankruptcy, and also concerns potentially about property that might have equity in it that might be at risk if you filed a Chapter 7 bankruptcy. And so if there are any of those issues present, then we would discuss a Chapter 13 bankruptcy, which still is going to give you an opportunity for a fresh financial start to get a discharge of your debt. Essentially what it does is the court sets you up on payments that you would make monthly to a Chapter 13 trustee for payment on your debt over a period of time, and typically it would be between 3 to 5 years.
Yeah. So, as we learned before, things like IRS debts, you're probably not going to get discharged on everything, things like that, because the government made the rules, so they want to get paid.
Exactly. Typically, taxes are non-dischargeable. There are some exceptions to that, depending upon the age of the tax debt.
And student loans?
Student loans are non-dischargeable unless you can show it's an undue hardship, which is a very, very difficult standard to meet. I was asked to present at a CLE about discharging student loans in bankruptcy, and it reminded me of that line from Dumb and Dumber. So you're telling me there's a chance? I mean, after doing what are the odds? About 1 in a million.
Best sales pitch ever.
Yeah. So it's difficult, but our firm has been successful in obtaining some discharge of student loans for some clients, overcoming that threshold. And at least if we cannot get a complete discharge, sometimes by filing the case, we're able to negotiate some reasonable settlements to lower the payments and make it something that the client can't afford moving forward.
Okay, so what are some of the biggest reasons that you see for filing bankruptcy?
Medical debt is a huge one, especially when the economy was struggling and people were losing jobs. Not only were they suffering a loss of income, but if they lost that job, they lost medical insurance coverage. And so then would have an unexpected medical event and would wind up with tens of thousands, if not hundreds of thousands of dollars in medical debt that just couldn't pay. I think lots of times bankruptcy kind of gets bad inference, I think, drawn about bankruptcy, but very rarely do I ever meet with someone that I think's just been careless and has just gone out and just blown a bunch of money and racked up a bunch of debt and now is in to discharge it. It's always tied to something horrible that's gone wrong in someone's life, and they're needing to look at other options. But the great thing, and I'll tell all the listeners, just like I tell any client that comes into my office, just because you see me about a bankruptcy doesn't mean that that's what we're going to do. It may be our best option, but it's our last option. So anybody that comes in to sit down and meet with me, we're exploring every other alternative short of bankruptcy, and we're discussing all of those options. And just to make sure that it's right, because it's not right for everybody.
Could you call their creditors or help them to arrange maybe different payment terms?
I do, and lots of times people will come in to see me, and there's really no debt threshold that you have to have in order to be eligible to file bankruptcy. But really in meeting with clients, that's something I'm considering, is what is the amount of debt that they have, because Once you have filed a petition for bankruptcy and you've requested that relief, for example, if you file a Chapter 7, you can't file again for another 8 years. So I want to make sure that if we're taking our bite of the apple, that it's the right time to do so. And so,
Right.
looking at the level of debt and what their income is and other resources, sometimes we will take the approach of just contacting these creditors and attempting to negotiate settlements and workouts outside of bankruptcy.
Right, so what you're saying is, bankruptcy isn't going to be the solution to all your problems if you have other factors that are causing you to be bankrupt. So, let's see, I mean, if it's because of medical bills, are you still sick? Are your medical bills still coming in? Have you addressed that with, getting insurance or something like that?
Yeah, exactly, exactly.
Well, I have a question that's not on the script actually, because maybe you said discharging debts, but you can also discharge certain contractual obligations, right?
That is correct. If you're in a lease agreement that you're not happy with, you have an opportunity to reject that lease agreement. So if someone's renting at the time we file and there's issues with a landlord or some type of rental agreement, we have an opportunity to reject that. I mean, really the idea from bankruptcy is if you're going to do that is to get a fresh financial start, really, that you would walk away without any debt. When you start reaffirming debt, whether it be a house or a car, it's something that actually is pretty closely scrutinized by the bankruptcy court if you're going to file a reaffirmation agreement in order to continue paying on that secured debt. The same with a lease.
Right, so if you were in a different financial situation than you are currently, and for example, maybe you have a $1,500 a month lease payment on an apartment or condominium in Branson on the lake, and you simply can't afford it anymore, but you don't know any other way to get out of that lease.
Yeah.
Bankruptcy might be an option there.
It is, and lots of times that's, if things have gone bad and there's been a job loss, you would have, incurred those obligations at a time that you were making an income and able to do so, and if there's been some circumstance that's required to change, that we'll want to be looking at the entire financial picture, because what I'm working with my clients is I just don't want to fix the problem now. I want to hopefully put them in a position that moving forward, we've gotten things put in place that they're going to be able to continue living and not be back in this position just a few months, few years from now. So really anytime I have a client that's wanting to reaffirm debt, we're having that conversation about what that would look like, what that means, and if that's really truly in their best financial interest.
So when somebody calls you up and says, I think I might need to file bankruptcy, you're really going to give them several options.
That's correct.
And it's Chapter 7, Chapter 13. Just talk to your creditors and see if there's another way out. You work with them on their budgets and things like that?
I do. I do a lot of work with them as far as just sitting down and looking at what their budget is and where can we cut some expenses in order to maybe to have money to try and put towards certain obligations to try and settle with those creditors outside of bankruptcy.
Right.
I work with them trying to move forward in planning because it's important because once they've filed bankruptcy, the fact that they filed bankruptcy is going to show on their credit for 10 years. Doesn't mean that they're not going to be able to get or acquire any new debt or acquire any new credit within that time period. They're going to get credit card offers in the mail very quickly after filing, and ultimately it's really important that you start utilizing credit again because you've got to rebuild your credit after having filed a bankruptcy. And so really what I do is work through those issues with clients and kind of trying to coach them on proper ways to do that and to rebuild credit and hopefully not fall back into the same position.
Right, and bankruptcy is not the end of the world, and that's something that I talk to clients too. And we mentioned on the show is about your credit report. I mean, your credit score is important, and if you just crawl into a hole because you filed bankruptcy, you're not doing everything you need to do, because a bad credit score could prevent you from getting a job, could cause your insurance to go up, could make you pay higher rates on your loans and all kinds of things. So definitely you want to work on that credit score. You want to get some credit so that you can work on your credit score.
Exactly, and I have had some clients that have been referred to me from an employer or from a lending institution simply to file because once we filed, their credit score actually goes up. The good thing about filing is it gives you a fresh financial start. It's drawing a line in the sand. Really in what I have clients in and they want to beat themselves up and feel terrible about what's happened, and that's not what we want to focus on. That's not where we're at. Our focus is on the future. And what can we do as an office to help you into the future? and not focus on what's happened in the past. We really can't do anything about that, but we can help with a bankruptcy, and we can put you in a good position moving forward in the future.
Let's talk some more about the difference between 7 and 13, if you can.
Yes, in a Chapter 7 and in a Chapter 13, essentially a trustee is appointed to oversee your case. People think, oh my gosh, I'm going to file bankruptcy, I'm going to lose all of my property. That is very rarely the case. Does any client or anybody that's filed bankruptcy lose their property? For the majority of cases, we're able to keep all of their property and protect all of their property through exemptions that we have. In a Chapter 7 case, the trustee that's appointed, his or her duty is to try and find assets or money that the individual that's filing bankruptcy has that they could take and liquidate or sell in order to have money to pay to creditors. Now, that sounds horrible, but again, under the law, we have tools that I can use as your attorney to protect and exempt your property that basically says, trustee, you can't take and you can't sell this property. My debtor is going to get to come out of bankruptcy with this property. And the majority of cases are cases where people are able to file and keep their car, keep their house. But again, when they meet with me, and the good thing is our office offers a free consultation, so it's not going to cost you anything to come in and sit down and explore your financial opportunities and decisions that can be made in this arena. And if there's any issue with property that an individual might lose if they're going to file a Chapter 7 bankruptcy, that's where we can always file a Chapter 13 bankruptcy and propose to keep that property, and essentially by making payments to their creditors over a period of time, which would be between 3 to 5 years.
Well, even on a 7, you can reaffirm some of your debt.
You can, that is correct.
So you can decide a lot of times if you want to keep your car,
Mhm.
or if you want to keep your house.
That is correct.
So depending on how much equity you have, I mean, if you just bought a brand new car, like I said, a lot of people, their situation might change. They went from making $160,000 a year to making $50,000 a year because of their job situation, or maybe they went through some marital problems, or whatever the case may be, and their whole life changed. And now they've got a car they can't afford, an apartment they can't afford, a lease somewhere they can't afford. And you can sit down with them and go through all of these different situations and help them make better financial decisions.
That is correct. Yeah, we can look at it and talk about that maybe it's best that they don't keep that vehicle, and that they surrender it in bankruptcy and turn the vehicle back over to the creditor and receive a discharge.
Right. So you won't necessarily lose your house or your car, but you may give it up. But now, what are the exemptions actually for the car and the house?
Well, bankruptcy is filed under federal law, so it's filed in federal court, in the bankruptcy court, but it applies Missouri state law from exemption purposes. For example, your home, that's your primary residence that you're living in, we can protect up to $15,000 of equity in that home. Now, $15,000 is the exemption from a practical matter. If a trustee is going to try and take and sell your house, he's going to have to hire a professional to do so, and is likely going to have to pay that individual some money for doing that service. So, ultimately, when I'm looking at it, that number in my mind kind of goes to $20,000 to $22,000 of equity, and we're in a pretty good place of being able to file and keep someone's house.
So is one option then to borrow up to a certain amount on your home to pay off your other debts?
That,
your home, or?
That's a number of options that people would explore. I can't encourage anybody to acquire a new debt in order to satisfy other debt, but that, we'll be looking at everything. And,
Okay.
I think it's something that somebody's got to consider. I mean, if they know we're going to file and we're going to lose a home, there's other options and things that they can look at and consider with how they're going to want to.
So it's complicated. You need an attorney.
It is complicated. I mean, there are a lot of pitfalls, especially like I said, it's a federal process, but it involves Missouri state law, and so there are some questions as far as disclosures on the bankruptcy petition if you're going through and filling it out yourself that is not going to be relevant to issues that could cause a significant problem.
Mm-hmm.
I mean, for example, it's going to follow Missouri fraudulent conveyance law, and so there's nowhere in the bankruptcy petition and schedules that it asks that you transfer property to a family member or relative within a certain time, because it's drawn up from a federal perspective. But if 3 years prior to you filing bankruptcy, you got added to the deed of your grandparents' farm, or you were on property and you just gifted it to someone. All of a sudden, if you did that without any financial consideration that you received, that's a fraudulent conveyance that the trustee could set that transfer aside. And so there's a number of things that I think if someone's just going through and filling out the petition and schedule it themselves, they would not realize the ramifications of certain actions that could cause some very significant issues for them in their bankruptcy.
Right. So they might, their bankruptcy might be worthless if it's not actually filled out and you don't ask the right questions.
Yeah, they could end up not getting a discharge or potentially be in a situation where had they realized the effects or consequences, they may not have chosen to file because of the way it would have affected that asset.
Right. So Chapter 7, if I understand it, is really the discharge we're talking about, where people are afraid of losing things, but they are protected by Missouri law to not lose everything.
Yes.
So 7 sounds like a pretty good alternative. Now, sometimes you say if there is a situation where they might lose something that they don't want to lose, you might go to a 13. Is that what you said?
That is correct.
So what's the difference in a 13?
Yeah, Chapter 7 is about a 3 to 5 month process from the time you file until the time you get your discharge. You'll have your 341 meeting of creditors typically within about 30 to 45 days from when you file your case, and then about 60 days after that date is when your discharge would come through. In a Chapter 13, you're going to be making payments to the Chapter 13 trustee for a period of time, typically 3 to 5 years, depending upon the reason for filing the bankruptcy. If you're filing a Chapter 13 because from an income calculation standpoint you're not eligible for 7, then unless you're paying 100% of your debt off earlier, your required time to make payments would be 5 years. Now, where we might choose to file a 13 while you're otherwise eligible from an income standpoint for a Chapter 7 is if you were going to lose an asset that you wanted to protect. Mm-hmm. So let's say you had a home that after you were paid your exemption, after the lien was paid on that home, your Chapter 7 trustee was going to have $20,000 that he could pay to, or she could pay to your creditors in your bankruptcy case. I could work with my client, and what we could do is file a Chapter 13 and propose to pay to the creditors the same $20,000 that they would have received under my example in a Chapter 7, and allow that individual to stay in their home where they would not have been able to do so had they filed the Chapter 7.
Okay, so the 13 is kind of the second thought usually. It's like, let's look at a 7. If you qualify, see what you're going to lose. If it's not a good situation, let's look at a 13. I guess that's the first thing you're going to look at is just talking to the creditors and not file bankruptcy at all. At 7, then maybe 13.
That is correct. If I can, my hope would be is to be able to get everybody qualified for a 7, but it doesn't always work, and 13 is a good option.
And do you want to talk a little bit about the amount of income you could have, and like you alluded to, you can't file a Chapter 7 if you have too much income.
Yes, and I'll talk a little bit about income. And the court back in 2005, when some changes were made to the bankruptcy code, went to a means test. And so what they're doing is looking at the average monthly income for your household over the 6 months prior to the date that you filed bankruptcy, taking that monthly average and determining what your yearly income would be based on that monthly average, and then comparing it to a household of your size, the median household income for a family of the debtor's size in the state of Missouri. And so, these numbers adjust, but the most recent numbers I have, and again, there's some wiggle room here on these. For example, a family size of 1, basically $44,286 or under, and you can file for Chapter 7. $54,000 and some change for a family of 2, $63,000 and some change for a 3-person family, and $74,000 and some change for a 4-person family. Again, there are a number of other factors that go into it. It's not just solely based on income. You could be above this income threshold, but if the majority of your debt is non-consumer debt, so it would be related to a business that was failed that you have personal liability on, then you don't have to look at the means test calculation. It's not applicable to determination of that situation.
Okay. What about the idea of bankruptcy protection? What does that include, and when does it start?
I think ultimately that's one of the most important things to look at and work with your clients is basically exemption planning from a bankruptcy perspective. You know, I'm meeting with clients, I'm looking, are there assets that are exempt? You know, if they, you know, I had a client that had a failed business, and because of that, some favorable taxes, you know, was getting in excess of a $10,000 tax refund.
Mm-hmm.
You know, if he just had that in cash at the time we filed, you know, the trustee is going to be in a situation that they're going to be, you know, coming after that money. So what we're really looking at is, are there things that we can do and planning in order to protect assets and timing-wise as far as the filing of bankruptcy? Are there things that can be done to put the client in a better position if they do have to file?
Well, I like to tell small business owners, for example, contribute to your IRA every year because that money's protected.
Exactly.
So that's one example. But like I said, it's a complicated issue, and we can only touch on so many things today. I appreciate coming out and talking to my audience
we sure do.
about it.
So you say, I'm just asking this as a question, Scott. For this guy, people out there, the shame that some people feel, and I've been there a while back, I did, should be set aside to come in and just personally talk to you.
Exactly. I mean, one of the things that I enjoy most about my job is you know, when I go up and greet the client for the first time in the lobby, I can see just kind of the fear and the you know, hurt, and that they're kind of ashamed to, in respects, to be there. And I don't want to focus on I want to focus on where we can go. And really, you know, once they've sit down and meet with me, I don't want them worrying anymore. That worry is going to become mine, and to address it, and, you know, just seeing how they walk out the door lighter because they've had some burdens and stress that they were facing, you know, lifted off their shoulders. It's, you know, I really enjoy meeting with people and discussing their financial options. And like I said, we're talking about bankruptcy, but it's not going to be our first option.
You've been listening to Scott Smith. He's with Rooney McBride & Smith. Their phone number is 417-708-9681. We're also sponsored by Michael Miller. He's family back and neck care, chiropractor and acupuncture, 889-2225. I'm Gary Bingaman with A&D Mechanical Services, 417-866-8257. We're also supported by Marilee Doherty, Clarity Insurance and Financial Services. Her phone number is 887-6261. Scrivener Solutions. Her phone number is 417-501-9072. Don't want to forget our guest, our host. Great job today, John. And John Dittrich, he's financial planner. His phone number is 881-0445 through DB. Okay. Guys, have a wonderful and great week. Springfield, listen next week as we got Dr. Mike Miller. He'll come on. Go ahead and get some of your questions ready when you come back next week on It's Your Money Radio, where you can make more money, you can save more money, and you can have more money for all your financial needs.